Good afternoon, ladies and gentlemen. I'm Michelle Easton, president of the Claire Booth Luce Policy Institute, and I want to thank you all for joining us for our June Conservative Women's Network lunch. Special thanks to co-host Bridget Wagner here at the Heritage Foundation. We've been doing this for many, many years now, and every month is a treat to work with Heritage. Two things before I get to my introductions. First, please turn your phones off, and then we'll have a quiet session. I always forget myself sometimes. I have to be reminded. And secondly, before I introduce our wonderful speakers, I want to see if any of you in the audience have any announcements, as we like to network, about upcoming events. If you're looking for a job, if you want to hire somebody, we'll start here. Tell us your name, please.
Sure. Everyone, Heather Fitzmeyer, I direct the Young Leaders Program at the Heritage Foundation. It's great to see all of you here, especially so many young conservative women. We actually have a couple great events here at Heritage that I wanted to invite all of you to. Our first is coming up July 10th and 11th. We partner with the Eagle Forum to do our Collegians Network. It's a great opportunity for 2 days to hear from a lot of congressmen, conservative authors, heroes. And on the second day, we actually do a book fair. So we take all books donated from staffers around, and all the proceeds go to the Wounded Warriors Project. So it's a great opportunity for those of you in the crowd who have books. Let me know, and I'd be happy to take donations. And then also the invitation for both of those events. We'd love to have you join for the book fair and the Collegians. We're also partnering with Susan B. Anthony for our Conservative Summit the week after. So another great half-day session focusing on marriage and the family. A great event also here in Allison Auditorium on June 15th. And then for the ladies in the room, we can't get enough. Tonight is a Network of Enlightened Women's reception here, and their conference is all day tomorrow. So if any of you have not signed up, it's the Network of Enlightened Women. Another great opportunity to network and a solid day of programming tomorrow. So feel free to come and find me if you have any questions. It's Heather Fitzmeyer at heritage.org.
Terrific. Anyone else? Yes.
Good afternoon, everyone. I'm Samantha Adia. I'm an intern at Claire Booth Luce. On Monday the 23rd, we have an event at the Visitor Center at Copperville Hill. S.E. Cobb, Amanda Carpenter, and Frank Donatelli are speaking. It's men and women. Everyone is welcome. Please feel free to register online, and we would love to have all of you.
It's sort of a career-focused seminar. How to be a strong professional and hold on to your conservative credentials and beliefs. Anyone else? Yes.
Hello, my name is Vanessa Oblinger. I am at a PR firm in Old Town. We're actually moving, which explains the jeans thing, so I apologize. But we are looking for an intern for the fall to do some either digital web design or public relations and communications stuff. So find me. I've got some cards, so love to talk to you guys.
Okay, Vanessa, thank you. Anyone else? All right. We have a great panel of women with us today to discuss the important issue of our religious liberties. They will specifically talk about the Hobby Lobby case before the U.S. Supreme Court and how the decision will have important implications for us. And that decision is just a matter of days away. First up will be Adele Keim. Is that correct, Keim?
Keim.
Okay. Who serves as legal counsel at the Becket Fund for Religious Liberty. Previously, she spent 4 years as an associate in the appellate practice at Winston & Strawn in Washington, D.C. For 1 year, 07 to 08, she clerked for the Honorable Edith Brown Clement on the U.S. Court of Appeals for the Fifth Circuit in New Orleans. Before she became a lawyer, Adele worked for a Canadian Member of Parliament and spent 2 years covering international religious freedom and social issues for the Evangelical Fellowship of Canada. Adele received her A.B. in politics, magna cum laude from Princeton University in 2011, and graduated from Notre Dame Law School with honors in 2007. Then we will have Congressman Cynthia Lummis of Wyoming. Elected in 2008, she's the sole House representative for the state of Wyoming. She's a staunch advocate for fiscal responsibility, limiting the size and scope of the federal government, and developing our nation's domestic energy capabilities. She was raised on her family ranch in Laramie County, graduated from the University of Wyoming with bachelor degrees in animal science and biology. She returned to the University of Wyoming to earn her law degree. She then clerked at the Wyoming Supreme Court, practiced law in Cheyenne, and served a total of 14 years in the Wyoming House and Senate. In 1979, she was the youngest woman ever elected to the Wyoming legislature. She and her husband, a former Wyoming legislator and Cheyenne attorney, have one daughter, Annalise. Then rounding out the panel from the Heritage Foundation is Sarah Torrey. As a policy analyst for Heritage and the DeVos Center for Religion and Civil Society, she focuses on policy issues related to religious liberty, marriage, and family. She posts regularly about family and religion topics on The Foundry, Heritage's policy blog. Her work has been cited by the New York Times, and her commentary has appeared in major newspapers and digital journals like National Review Online. She appears regularly on radio programs across the country and speaks to student groups and audiences on Capitol Hill. Sarah received her bachelor's degree from Villanova University. She's a native of Pennsylvania and currently resides in Alexandria. Please join me in thanking all the panelists for being with us today, and we're going to start with Adele.
My daughter graduated from Harvard, which is just down the street.
Good morning. It's a pleasure to be here. Thank you so much to Claire Booth Luce for organizing this. So, I'm a lawyer. I work for the Beckett Fund for Religious Liberty. The Beckett Fund, if you haven't heard of us, is a small nonprofit law firm. We focus on one thing and one thing only, and that is defending the principle that religious liberty is a human right and every person deserves it. We like to say that our clients have included everybody from A to Z, Anglicans to Zoroastrians. And I've been invited here today because one of our clients is Hobby Lobby. Hobby Lobby, Mardel Christian Books, both founded and owned by the Green family, who are evangelical Christians, and they're challenging the HHS mandate. What is the HHS mandate, you say? Well, it is a rule adopted by federal bureaucrats, not Congress, that requires most employer-provided health insurance plans to cover contraceptives in all the FDA-approved forms, including the emergency contraceptives that are used after the fact and may end up destroying a newly created human life. So, did everyone get a handout? You can look at this. All right, now's the time to pick this up and look at it. Our folks put a lot of work into this. You can see here that there have been over 100 cases filed to challenge the HHS mandate on religious liberty grounds. I think that in itself is a victory for religious liberty. Those 100 cases include hundreds and hundreds of individual and organizational plaintiffs, both for-profit businesses like Hobby Lobby and nonprofit organizations like our clients, the Little Sisters of the Poor, and the nursing homes that they run across the country. Now I want you to look down at this part right here. You see that? We like to call that our scorecard. Green means we're winning. So the record in the for-profit cases is 40 times. In 40 cases, the courts have defended and protected religious liberty against the HHS mandate. And in just 6 times, the courts have said, no, the government gets to do what it pleases. Then look over here at nonprofits. 23 times the courts have defended religious liberty, protected religious liberty, the religious liberty of nonprofits, and just 5 times have they denied an injunction. Friends, we're winning. That's 5-1. We're winning. Now, we're here to talk about particularly the 2 HHS mandate cases that are before the Supreme Court right now, Hobby Lobby and Conestoga Wood. Hobby Lobby and the Green family are my clients, so I'm going to focus in on them for a while. Let's take a spotlight. Husband and wife team, David and Barbara Green, founded Hobby Lobby in their garage, where you found a business, in 1972. They've since grown. It's now a multi-billion-dollar business with stores across the country. And today, but it's still completely controlled by the Greens and their sons and their daughter, Darcy Lett. They also have founded and operate a chain of Christian bookstores called Mardel Christian Books. The Greens have always worked to run Hobby Lobby and Mardell in a way that reflects their Christian beliefs. So probably the most well-known example of that is they close their stores on Sunday to give their employees a day of rest. But they also do it in other ways. They pay their employees a starting salary that's 90% above the federal minimum wage, way above GAAP. They offer generous health benefits because they know they have employees who rely on them for that protection. Single moms, parents of families who need health benefits. And they donate more than 90% of their profits, their personal wealth, to charity. All the Greens want to be able to do is to continue to offer their employees generous health benefits that still comply with the Greens' conscience. They've always had the right to do that, but until the HHS mandate. And let's be clear also, the Greens don't object to much. They're evangelical Christians. They don't have an objection to contraception per se. In fact, their health plan already covers things like the pill, the form of contraception that most American women favor. They only object to the narrow class of 4 drugs and devices that may end up destroying a newly created human life. And that's because they believe that human life is a sacred gift from God and must be protected. Now, let's step back. I said a minute ago that the HHS mandate applies to most employers who offer group health insurance. The reason I said most is because Congress actually exempted health plans covering about 100 million American workers from complying with the mandate at all, so long as those health plans remained grandfathered. That is, the same as they were in 2010 when the ACA was passed. So in other words, those big businesses covering almost 100 million American workers can do whatever they want, as long as it's the same as what they were doing in 2010. So it doesn't apply to everybody, and it doesn't apply equally. But what the government has said is that they will not give an exemption to the Greens for religious purposes. So let's get this straight. They'll exempt businesses that cover 100 million workers for political reasons, to keep the president's promise that you can keep the plan you have, but they won't exempt a single religious business owner who has conscience objections to the mandate. That doesn't sound right to me. Now, the government claims that it is defending the rights of the Greens employees. But the government also says something else. It says that the Greens aren't really burdened by the mandate because, after all, they're free to just drop all of their employees' health insurance and pay a little fine. $26 million isn't a little fine. But more importantly than that, you heard me a minute ago, the Greens feel a religious obligation to provide for their employees. They know they've got single moms on the payroll. They know they've got parents with sick kids. They know they've got employees that depend on them. For them, dropping all employee insurance is not an option. It strikes me as pretty outrageous that the same people who claim to be worried about the impact on employees of excluding 4 widely available contraceptives are also suggesting that the Greens just drop all health insurance and not pay their employees a penny more to compensate. I think that Barbara Greene said it best on the steps of the Supreme Court. She said, "Our family started Hobby Lobby, built on our faith, and together. We've kept that tradition for more than 40 years. We want to continue to live out our faith. We believe that no American should lose their religious freedom just because they open a family business." The Supreme Court is scheduled to decide this case before the end of the term on June 30th, so stay tuned. Now, that's normally where I would end this talk. However, if you'll allow me, sure. I want to say something particularly to you in this audience. I want you to leave here. I hope you've been encouraged by what you've heard so far. I hope you feel a little bit bolder about the HHS mandate and the claims that the Greens have brought. But I also want to leave you equipped to speak out if you end up in conversations or Twitter conversations or on Facebook about this. And that's why we've given you this handout with information that you can use. Because you see, something that we've continued to hear is that these HHS mandate plaintiffs are waging a war on women. Now, I don't think that Barbara Green and her daughter Darcy Lett are waging a war on women. But when the government adopts a set of rules that coerce even the Little Sisters of the Poor and Mother Angelica from EWTN into facilitating contraceptive coverage for their employees, that sounds an awful like the government's war on nuns. In fact, the government's argument that Barbara Green and Mother Angelica should just drop all their employee health insurance would harm their employees, including their women employees, way more than excluding a few relatively inexpensive and widely available drugs. You're also likely to hear a lot of talk about the way that this case supposedly divides men and women. In fact, one of my favorite examples of this was right after oral argument before the Supreme Court in March, when Cecile Richards, does anybody know who that is? She's the president of Planned Parenthood. She stood on the steps of the Supreme Court and she said, "What I think we saw today was the importance of having women on the Supreme Court." Really? This is 2014. And the president of Planned Parenthood thinks she can assume that women judges are going to vote their gender? Here are the facts, and these are also on your sheets. When you look at the HHS mandate cases decided by federal judges, women judges have voted to stop the mandate 24 out of 39 times. That's 61% of the time. In the for-profit cases, 2 out of the 4 courts of appeals that voted to protect religious liberty did so in opinions that were written by women. Judge Diane Sykes on the 7th Circuit and Judge Janice Rogers Brown right here in DC. And those are, I will tell you as a lawyer, those are 2 of the leading, best reasoned opinions you're going to find out there in the for-profit cases. In the nonprofit cases, women judges have voted to protect religious liberty by a margin of more than 2 to 1. That number includes Judge Lee Rosenthal of the Southern District of Texas, who has written what some regard as the leading district court opinion on this issue. It's the only opinion that the couple of people who have ruled the other way even bother to take on because it's the best. Judge Marcia Krieger of the District of Colorado, Judge Joy Flowers Conti, she's the chief judge of the Western District of Pennsylvania, and Judge Amy Berman Jackson, who's an Obama appointee right here in DC. So, I hope you were encouraged by the first half of this talk. I hope you were emboldened by understanding more about the claims, and I hope you feel equipped to go out and talk about this. Next time you hear someone talk about the war on women, I hope you'll remind them about Barbara Green and her daughter, Darcy Lett, the Little Sisters of the Poor, and Mother Angelica, and all of the women judges who have voted according to the law to protect religious liberty. Thank you so much.
What an excellent overview. I love the war on nuns. That's excellent. Now we have our outstanding Wyoming Congresswoman who signed an amicus brief in support of Hobby Lobby, and she's going to talk about that, and also her support of the Conscience Rights Bill. Thank you.
Thank you all for inviting me to join you today, and I want to thank you all for being here and caring about these subjects. Now, our 2 legal experts on this subject are to my right and my left. So rather than talk about the legal nitty-gritty, I'm going to let them do that, and I'm going to talk about how this has played out in Congress as a policymaker, people who are looking at the big picture rather than drilling down and really honing the legal arguments that will win the day, hopefully before the end of this month. Sarah is going to talk about the actual Religious Freedom Restoration Act of 1993, which is intended to apply to a broad array of federal legislation which has passed since 1993, protecting religious liberties. It is, of course, based on our constitutional rights under the First Amendment. The clauses that refer to religious freedom include the free exercise of religion and the separation, the Establishment Clause, the government shall not establish religion. So that act passed in 1993. Now, when Obamacare passed, it was very one-sided in that Democrats supported it, Republicans did not. Usually when major legislation like this that is transformative of the way our society functions is passed, it is done on a more bipartisan basis. This is one that, as a Republican, I feel was not properly vetted, did not go through committee, came to the floor of the House as a 1,200-page bill, at least, was impossible to read through in time to fully understand all of the ramifications. There are many unintended consequences. Too much of the policy was left to be drafted by bureaucrats. And the cost is exponentially higher than was first known when this bill was passed, even by Democrats alone. As has been stated, the regulations as they are now being drafted are proving even more onerous an attack on religious liberties, on the national debt, on other aspects of our individual pursuit of happiness and right to be left alone. I mean, this transcends so many elements of what the founders of our country believed that they were providing as a framework for our country. So this law is so transformative that it is important that those of us who feel that the direction it is heading, which is toward a large, centralized government with many mandates that prohibit us from earning success, pursuing our liberties, religious and otherwise, and being free of the debt obligation that is just going to impale people your age. And this law is going to contribute to that. So there are many reasons to repeal this law, reform this law, replace this law. And that fight is going to continue in the months and the years to come. I want to compliment the Green family, Hobby Lobby, and other business people who are strong in asserting the rights that all of us enjoy in this country, and to stick to their convictions all the way to the U.S. Supreme Court. 88 members of Congress signed the amicus brief, the friend of the court brief, that accompanied this piece of litigation to the Supreme Court. Now, prior to members of Congress signing the friend of the court brief, the amicus brief, we were briefed by this very, very wise woman, her very, very devout clients, And they are devoted to free enterprise, freedom of religion, freedom of religious expression, and to, as you can tell, the well-being of their employees. And they're trying to do that simultaneously. And they've hit on a marvelous formula to express their faith, to provide their employees with livable wages and benefits that allow their employees to pursue happiness. So they are a valuable, worthy client to protect and support. They are a fabulous representative of the rights that we're trying to protect. Now, they came, the Greens came to several groups that I attended in Congress before I signed on to the brief. Because when a member of Congress signs on to a brief before the U.S. Supreme Court, you want to feel good about the people whose rights you're protecting. Obviously, they're protecting all of our rights, but they specifically are a worthy family to support in their efforts, and the way that they are presenting themselves on behalf of all of us who believe in religious freedom is exactly the way you would hope. They're very sympathetic supplicants in front of the U.S. Supreme Court. That's part of the reason that they have so much support from the Congress. And so we could see that when we met with them. This is not a cold piece of paper that we signed on to. We signed on to the Green family and their ability to represent 88 members of Congress in the way we feel about this issue and the way our constituents feel about this issue. Now, the details of this rule are staggering. The government will fine companies that don't provide insurance $2,000 per year per employee. Okay, that's to somebody who doesn't provide insurance. But it will fine companies like Hobby Lobby and Conestoga, which provide the entire array of health coverage to its employees, except the 4 objectionable drugs and devices that were mentioned, $36,500 per employee. I mean, that is a extraordinary disincentive to employers to provide employees health insurance. So these people, the Greens, are caught between a rock and a hard place. And Supreme Court justices, in addition to trying to look blindly at the law, they're people. They can't look just blindly at someone who is a supplicant in front of them. These are very principled, moral, American people trying to do the right thing. And that's why it's an honor to sign on to this amicus brief. So they came and met with us, and we were impressed with their legal arguments, with the situation they are in, with their moral commitment to take this all the way to the U.S. Supreme Court, and we wanted to be with them and behind them. Their lawyers and they themselves have continued to keep Congress updated as to the progress. Many of us who signed on to the amicus brief wanted to attend the oral argument, but there were too few seats available, so only a few very important members of Congress got to listen to the argument live, including Speaker of the House John Boehner and people at that level. But this has had a great deal of attention within the Congress. So we await this decision as policymakers, as representatives of people who are reflected by the people in this room. who are concerned about these issues with great anticipation. And hopefully before the end of this month, we'll have a decision that will make us proud of our Constitution, our Declaration of Independence, our business owners, their employees, their faith, and our commitment to be one nation under God. Thank you.
Thank you so much, Congresswoman, for your work on this and for standing up, taking such a strong stand on it.
Thank you.
Really appreciate it. And now to do the wrap-up from Heritage, Sarah.
Thank you, and thank you, Adele and Congressman Lummis, for those excellent remarks. As the Congresswoman mentioned, I'm just going to drill down onto one of the federal laws that's at issue in this case, the Religious Freedom Restoration Act. So for the very beginning of this mandate, and its very narrow religious exemption, it basically only applies to formal houses of worship. The Obama administration has essentially argued that our robust protection of religious freedom should be watered down to a mere freedom to worship. Your faith can remain strictly a private affair under the arguments put forth under this mandate. You can practice your beliefs in your home, your place of worship, but you step outside those four walls to serve others like the Little Sisters of the Poor do, or to create jobs, grow the economy as the Greens and the Hans do, and your religious freedom ends, according to the Obama administration, under this mandate. But this kind of picking and choosing about who gets to live out their faith and how they work and how they act isn't consistent, certainly with our Constitution, isn't consistent with our founding, and it's not consistent with a federal law called the Religious Freedom Restoration Act. And while many people are very familiar with the Hobby Lobby case, they're often not as familiar with this fantastic law that has been very quietly and effectively working to protect our religious freedom for over 20 years. So I'll do a little bit of history lesson for you here. Back in 1990, the Supreme Court issued an opinion in a case called Employment Division v. Smith, and I won't get into the details, but basically it narrowed their protection for the free exercise of religion. And Congress was rightly, and many other groups outside of Congress were rightly upset about this. They recognized that we should have a much broader and more robust protection of our fundamental freedom. So they sought to restore that protection, and what resulted was the 1993 RFRA, Religious Freedom Restoration Act. And what RFRA does is it prohibits the government from substantially burdening religious freedom unless the government can show it has a compelling interest in doing so, and does so through the least restrictive way possible. So that's a very high bar for the government to meet, and one unfortunately has not met in implementing this mandate, certainly against these families. The support within and outside of Congress was very broad and bipartisan. It may have been the last broadly bipartisan piece of legislation the Congress has passed over the past couple decades. It was sponsored by then Representative Chuck Schumer, a Democrat from New York. In the Senate, Ted Kennedy and Orrin Hatch sponsored it. It passed in the Senate by 97-3 and by a unanimous voice vote in the House. So there was great support for this. Even outside of Congress, a diverse coalition of about 68 organizations, including some strange bedfellows. The American Civil Liberties Union was working with the National Association of Evangelicals, which were working with many groups from Jewish and Muslim and Sikh and Christian organizations. But this consensus demonstrates the truth about why we should protect this fundamental right, and it shows how fundamental the right to religious freedom really is. Individuals' ability to seek the truth, to form consciences, to live according to the dictates of those consciences, are fundamental to who we are as humans, certainly fundamental to who we are as Americans. And it doesn't matter what side of the aisle you're on, what ideology you come from, what religious faith background you come from. We can recognize that this freedom is so fundamental that we shouldn't allow government to unnecessarily burden how we exercise that faith. And something that's often not misunderstood about RFRA, despite its very strong deference to religious freedom, it doesn't allow individuals to simply do whatever you want in the name of faith, in the name of religion. It's simply a very common sense way of balancing this fundamental right with compelling government interests. It doesn't dictate what will happen in a particular case. It's a case-by-case basis kind of law, but it simply provides the means for courts to determine, to balance these two compelling interests and this fundamental right. And it's worked well for over 20 years. We've had many cases where the government can show it has a compelling reason for burdening religious freedom to ensure public safety, for instance. But federal RFRA sets a very high bar for the government to meet in order to do that. And like I mentioned before, the cases before the Supreme Court fail, the government fails to meet that high standard. The mandate coerces families like the Hans and the Greens to violate their faith by providing drugs and devices that they believe can end the life of a human embryo. And the government didn't need to enforce the mandate in this way. There are plenty of other ways the government could have provided these drugs and devices to people who wanted them without hijacking an employer's plan and forcing them to be complicit in the provision of this and disregarding a fundamental freedom in the process. And what's important to understand about the thought and the intent behind this law and our protection of religious freedom more generally is that it's a freedom that doesn't just include what people do in private or at weekend worship services. America's conception of religious freedom provides every person the freedom to seek the truth, to form beliefs, to live according to the dictates of his or her conscience, whether you're at home, in worship, or at work. These fundamental beliefs help us make sense of the world, and they can't be lightly discarded, and they can't be the subject of bureaucratic negotiations at HHS. And that religious liberty can only be meaningful if it applies to everyone, not just those that the government picks and chooses who's going to be able to live out their faith, which is why all Americans, whether or not you agree with the Hans or the Greens, you can disagree with them, you can not share their faith or share their opposition to abortion, but you can understand that the government shouldn't be able to force Americans to violate their faith, and that's why every American should be concerned with how the Supreme Court rules in this case. And then just one more minute, I'll just talk about the second huge federal law that's obviously involved in these cases, and that's Obamacare and the Affordable Care Act. As Congressman Lummis mentioned, this particular mandate was not created by Congress, was not written into the law. As with so much of the Affordable Care Act, Congress simply handed over extreme authority, very broad authority, to bureaucrats at the Department of Health and Human Services to create this mandate and to define the boundaries of this mandate for almost many, if not all, qualified health plans in the country. So this kind of broad, centralized government authority handed over to unelected bureaucrats who are unaccountable to most is not a system that's going to be conducive to protecting religious freedom, certainly in this instance and in instances going forward. The HHS mandate is only Exhibit A, only a very early warning sign of what's to come under Obamacare. We've given broad authority to bureaucrats to simply create more of these mandates, potentially more onerous, on other sensitive healthcare issues, whether it be abortion or IVF, end-of-life care. They can make these mandates with simply the stroke of a pen. So if we want to, obviously we're very hopeful that the Supreme Court will respect the religious freedom, protect the religious freedom of the Hans and the Greens in this case. But if we want to take the long view to protect conscience in healthcare, we're going to need a healthcare system that is patient-centered, that allows individuals and families to choose a plan that aligns with their values for themselves, allows employers to find a plan that they can provide to their employees that aligns with their values. And despite our many differences on matters of conscience and our differences on all of these controversial issues, all Americans should be able to recognize that we should work together to protect freedom of conscience in healthcare.
What an excellent discussion. Thank you so much, Adele, Congressman Lummis, and Sarah. Don't you feel refreshed or newly informed of this decision coming down next week? Just a great time to have this discussion. We have a little bit of time for questions, right, Bridget?
Yes.
And if you would not mind, oh, here's a Clear Booth Loose intern there from Virginia Tech, Lauren.
Yeah.
And is there another one, another mic?
So if anyone has a question.
Okay. If you wouldn't mind, give your school and your name and your affiliation. If you're a student, give your school too. It's always interesting. Okay. Questions?
Let me ask a quick one.
So the court, the pattern of the decision, and this might be for Beckett Fund, and then the second half of the question for maybe Sarah. What happens when the court releases a decision? What's that process look like? What time of day? When do you expect this? When should everybody be kind of following the news that day for announcement? And then, Sarah, if you can help us, besides Beckett Fund and Heritage, who else? I'm assuming everyone in this room under the age of 30 is on social media of some form. Who should they mark today on their Twitter or on their Facebook to be able to see what the reaction is? Should the decision be complex? Who should they be looking out for?
Okay, so the decision, at this point, the Supreme Court has a tradition of always finishing its work before it breaks for the summer. It breaks for the summer on June 30th. So at this point, you can know with certainty that the decision will come down sometime between today and June 30th. Now, you don't need to be checking your email for the decision on Saturday night because the Supreme Court does not release decisions on Saturdays. Traditionally, it releases decisions at this point in the term, it releases decisions on Mondays. So you're going to be looking at 10 a.m. on Monday, June 23rd. And then if they don't hand down Hobby Lobby that day, the Chief Justice is probably going to announce a couple of additional days because they've got almost 10 decisions left, and they try to only release like 3 or 4 at a time so everybody can read them and digest them. So we expect that next week on Monday, okay, we'll also release some opinions on Wednesday, maybe on Thursday, and then on the following Monday, June 30th, that's D-Day. If you haven't heard, so here's a rule of thumb. If you haven't heard anything about Hobby Lobby by like noon on Thursday, so a week from today, it's going to be at 10 a.m. on June 30th. The second little tip I would give you is the best place to get information about the Supreme Court is SCOTUS blog, SCOTUSblog.com. They are on their game. They are at the court every morning. They are they keep statistics on who writes what opinions. If you want to nerd out about this stuff, SCOTUS blog is the place to go. And they live blog it every time there's going to be an opinion release. So that's where I would go.
And then in terms of social media, Beckett actually, and I guess Hobby Lobby has a Twitter handle. It's at Hobby Lobby Case. They'll have really great information on that, on the decision, some details about that. You can also follow ADF Media. Alliance Defending Freedom is the other law firm that's representing the Hahn family who runs Conestoga Wood. Their cases were consolidated before the Supreme Court, so both of those families are waiting to hear from the court. And then you can follow me because I'll be doing it. It's just at Sarah Torrey. And yeah, we love retweets. We would love to have this, to have our messaging out there about this case as soon as possible.
Great, thank you. Other questions? Yes, if you hand her the mic.
Hi, Debbie, concerned citizen from Virginia. Anyway, you mentioned that the 1993 Act was very bipartisan. I think, Sarah, you did that. My question is, of the 88 signatures that's on the brief, how bipartisan is that group?
All of the senators are Republicans. Blunt, Alexander, Kelly Ayotte, Barrasso, Burr, Coburn, Enzi, Fisher, Graham, Hoven, Johans, Moran, Rubio, Scott, Toomey, and Wicker. Now, on the House side, there's just one? No, there's oh, yeah, Dan Lipinski, he's from Illinois, that's a Democrat. Mike McIntyre, a Democrat from North Carolina. Looks like just two.
There was another brief that was filed by senators and members of Congress who were in Congress in 1993 and had voted for RFRA, who did a separate amicus brief showing their continued support for the law and how it should apply in this case.
Okay, thank you.
And as a Virginian, I'm trying to see if we've got any Virginians Eric Cantor, of course. Randy Forbes, Rob Whitman. Anybody else?
Frank Wolf.
Oh, I'm sure he's on there.
He might have been on the other one, yeah.
Yeah,
He is, because he was there.
and I'm not seeing page 4, and since the last name on page 3 is Whitman, I wonder if he's just on page 4. Anyway, your Virginia members were very supportive.
Great.
Anyone else? Over here. This is Madeline. She's a high school intern at Claire Booth Luce from Oakcrest in McLean.
Hi, my name is Carrie Johnson, and I'm interning with the Federalist Society here in D.C., and I guess my question is for the Beckett Fund. But in the case that Hobby Lobby doesn't win, the court doesn't rule in our favor, what would the next step be in this, kind of fight for religious freedom? And I guess where would we go from there?
Friends, we think that we will win. We the cases are not over. You have the statistics in front of you in your handout. There are dozens and dozens of nonprofit cases that are making their way through the court, including through the courts, including the Little Sisters of the Poor. We already know that the Supreme Court has thought about the Little Sisters of the Poor because Little Sisters of the Poor had to go up to the Supreme Court on December 31st before midnight. The fines were going to kick in against the Little Sisters. And Justice Sotomayor, before she dropped that ball in the Times Square at New York, she said, stop. We will not allow this to go into force against the Little Sisters while we are deciding their case. And she put a halt to the mandate. Justice Sotomayor put a halt to the mandate herself. And then the Supreme Court took about 3 or 4 weeks to think about it, and they issued a per curiam order. They said, you cannot crush, government, you cannot crush the Little Sisters of the Poor with fines while they have their day in court. And they said, so they protected the Little Sisters while their case is making its way through the court. So there's a whole line of cases that are right now funneling their way through the courts. The winning record today is what you have on your sheet. And we expect the Supreme Court to pick one of those cases, whichever one wins the various horse races, and pick one of those cases and decide it by June 2015. So we should hear about this. You're not done hearing about the mandate. You're going to hear about it next week, God willing, but you're also going to hear about it next year.
Here and then here. Okay.
Thank you. My name is Emily Newman, and I'm interning here at the Heritage Foundation. My question is regarding the Hobby Lobby employees. Do we know their opinion about the court case going on right now, or if they're silent about it? What exactly, if we know anything, what it is that they're thinking about it?
That's a fair question. And I would, if I were you, I would look at the hobbylobbycase.com and see what's on there, see what's been on social media. I think the number one thing is that, Hobby Lobby's employees are currently being paid well and protected well in terms of their benefits. And I think like anybody, I can't speak for other people, but I think like anybody, they'd like that to continue. And so what's one of the most outrageous things about this case is that the government claims to be protecting the interests of the employees out of one side of its mouth, but out of the other side of its mouth, it tells the Greens, well, there's no burden on you because you can just drop all health insurance and not pay your employees anything more. Seems a little inconsistent to me.
And wouldn't you think that somebody who would apply for a job at a Hobby Lobby and wanted to work there would know that this is a very Christian-founded business that runs on those principles, and that they would probably tend to be aligned with the views of the employer?
There's a question.
My name is Della Healy, and I just wanted to compliment whoever wrote. Is this on? Mm-hmm. Whoever wrote the brief. I read it. I was at the Supreme Court, and it was brilliant. absolutely brilliant.
I'll pass those kind words on to
yourself
our
a
team.
favor.
Thank you.
I think there was a question right behind Della, or perhaps it was this lady. I think it was right behind. What's next? No? Okay.
Okay, thanks. I'm Kayla from Grove City College. I'm interning with the Heritage Foundation, and I'm looking at some different career options in law or public policy, and I just wonder, what are some ways that young conservatives can best get involved with this movement?
I think interning at Heritage is a good start. That's how I started. And I know you guys have internships as well, right?
Most of our interns are folks who are already in law school, so legal interns. And
I have a daughter who has two lawyers for parents, and she has a master's degree in digital media from Columbia, and has wondered the same thing about whether to go to law school. Quite frankly, I have encouraged her not to go to law school. And it has more to do with your personal qualities, and this is why I advised her. She has a talent for politics, and she can bridge through language and advocacy the gaps between policy and politics. And I think that's a very rare person who can do that. I went once to a Frank Luntz school where we had members of Congress on one side of the glass and people who were just brought in, who were nonpartisan, to listen to statements that we had made on television and critique us. And it's a little intimidating. We were out in Los Angeles on a beautiful LA day in a dark room, and here come in all of these people in T-shirts who are nonpartisan, and quite frankly, they just get paid $100 to come offer their opinions for an afternoon. So you get all kinds. And they didn't know us from a bale of hay, and yet we sat there and listened to them critique some of the things that we say. And I realized how you can, it's the way you communicate things so often that shapes public opinion. If you're good at that, like my daughter is, I think it's better to try and shape public opinion than it is to mop up the mess like these two gals are having to do. They're trying to mop up messes. And so pick your strengths. And if you're really good at the policy and the politics and the apex of those, don't go to law school. But if you're good at the sanitary, because once you get to the appellate courts, the Supreme Court, it's a pretty technical sanitary debate. It's not about the human element as much anymore. It gets down to technicalities. Now, if you want to be arguing about the facts and the human elements of fact cases, then maybe a trial setting would be better for you. But boy, it's a sterile atmosphere that these two are operating in. And they're good at it. And thank goodness that they played to their strengths. So I just say, really check out what's in here and play to that strength.
We'll go to the lady in green next, but let me suggest while the mic's getting to her, if you're a student on a campus, work with one of the campus-based organizations, Clare Boothe Luce Policy Institute, there's a number of them, and we'll help you bring in a speaker to have an event at your campus where you can discuss this issue. We'll help you do good flyers so people will come and disagree, and it'll be a vibrant event. Another thing as a student is to write for your school paper, write letters, write articles, write for your local paper, send them home. You're in Washington for the summer, and this is so important, and you need to let the local people know about it. And then social media. You're all on social media. Talk this up, enclose articles, enclose quotes from these ladies today. This will be up on the Heritage website and the Luce website in a couple days if you want to just watch it and get direct quotes. But there's a lot you can do, and then even beyond that, just talk to your friends, talk to your family. because now you've heard all this. You know so much more than you did before, and that wonderful sheet. There's a lot you can do, and if you want more ideas, come and talk to me. Yes, lady, please.
That's so great. My name is Caitlin Deering. I'm with the Heritage Foundation this summer, and this is super relevant to my campus right now because I go to the University of Notre Dame. And I was wondering if any of you had anything you wanted to offer about whether their case is likely to be successful, because the university is a little different. It's considered a place where people with all sorts of different opinions can come, but when it's a Catholic university, of course, it's different because there's that affiliation there. And honestly, I think the HHS mandate is a very bad idea, and I hope that Notre Dame's able to get out of it, but I just wonder what your perspective was on that, all of you.
Go Irish. As an alum, I was so proud of the university taking a stand against the mandate, and Father Jenkins has been a leading voice on this, engaging with President Obama from the very beginning. I think one thing to keep in mind about the HHS mandate is the administration knew that it was picking a fight with religious organizations that represent the overwhelming majority of Americans when it passed this mandate. They knew it. They went in with their eyes wide open. Father Jenkins and many, many others, Archbishop Laurie and many, many others who supported the ACA, who supported health reform, who supported universal health care and all kinds of other initiatives that were important to the administration, went in and spoke to them and said, please don't do this. You are putting us in a completely untenable position with respect to our faith. So I was very proud of Notre Dame for filing suit. They're represented by Jones Day, which is one of the top law firms in the entire country. They have some Notre Dame alums working on the case, and their lawyers are incredibly, incredibly bright and working incredibly hard. But I'll tell you something else. Judge Posner, who was the judge on the Seventh Circuit, so Notre Dame was the first nonprofit to be without protection from the mandate. Judge Posner, who is on the Seventh Circuit, who wrote the majority opinion, has been on record for years stating that he personally thinks the Catholic Church is wrong on contraception and should change its views. And you see that attitude in the way that he wrote his opinion, saying that there's no burden on Notre Dame's religious beliefs and they don't get any protection. So I think that he let his views be known publicly, and he let his views be known in how he ruled, and I think it shows the importance of judicial confirmations.
Do you know if it's true? I've read that when the Catholic leaders and others went in to the White House, they were told, don't worry, we're going to take care of your interests. You know, like, just kidding. Is that true? I don't know. Because they supported Obamacare. They must have been told something.
I mean, there was much public discussion about the mandate, certainly when it was first introduced, right, before it was finalized, right. And I won't go in to bore you with all the regulatory details of how many versions of this mandate we've had and versions of the so-called accommodation. But you know, time after time after time, even after, you know, hundreds of people would tell them, thousands of people would tell them that this was violating religious freedom. The Obama administration has remained dead set on enforcing this against people like the University of Notre Dame, as well as the other plaintiffs we've talked about here.
Okay, it's 1:05. Bridget, what, one more?
I think one quick question, and then we want to make sure that we leave plenty of time for you guys to network and have a chance to speak to our speakers directly.
All right. This lady's quick, I know. She's one of my interns.
Hi, my name's Peyton Roberts. I'm an intern for the Claire Booth Luce Policy Institute. In 2010, corporations were given the right to freedom of speech. Do you think that right of freedom of religion should be incorporated into corporations such as Hobby Lobby that have shown faithfulness to their religion, or do you think that could cause more problems than it's worth?
So two things in response to that. Number one, corporations in the United States have had, the default rule in the United States is that corporations have all of the constitutional rights that individuals have. That has been the law for more than 40 years. So the brouhaha about Citizens United creating new rights for corporations, as a lawyer, it's wrong. It was about a campaign finance law and whether Congress had supported its restriction on corporate speech with enough with enough findings of fact and enough kind of evidence to uphold it. So the second thing is that there is nothing in our constitutional tradition that has ever said that you lose your religious freedom, your First Amendment rights to freedom of religion, free exercise of religion, when you open a family business. No law has ever said that. No case has ever held that. This has been litigated all the way to the Supreme Court. The government has scoured the court records from 200 years, and they have never found a case outside of the last 2 years litigating HHS mandate issues that has said that when you open a family business, you lose your First Amendment right to freedom of religion. And you know what? That's a pretty big loss. And I think that the hundreds and thousands of business owners in this country would be very surprised to know that they lost constitutional rights when they opened a business. And that's why even the people who are on the government side on this, even law professors who have been blogging and supporting the government throughout this process, are now saying that they don't think that that's a very good argument. So we expect to see the Supreme Court weigh in on that. So.
We have some gifts for the ladies. Let's thank them again. We have our limited edition Claire Booth Luce Policy Institute coffee mug with her famous saying,
"No good deed goes unpunished."
And we have tote bags because ladies never have a tote bag.
Absolutely.
Thank you.
And I'll stay here. And from Heritage, we always love to give books. So for this panel, we thought it would be particularly appropriate to give them this great 2-volume set of Democracy in America. I'm sure a lot of the Heritage interns have heard about it, and they're studying it this summer as well. And Alexis de Tocqueville, as most of you know, wrote so eloquently about the civic institutions here in America, and foremost among them being religion, as he pointed out in the book. So thank you all so much for the work that you're doing to protect religious liberty. Thank you all for attending. We're going to have another Conservative Women's Network meeting luncheon next month. So if you haven't signed up to be on the email list, make sure you sign up outside. For those of you who are thinking about your careers, in addition to Michelle, Heather Fitzenmeyer stood up from Heritage. Be sure to check in with her and hear about other great organizations here in town. Sign up to get on the Heritage lecture list, and be sure to visit all of our friendly think tanks while you're here in Washington, AEI and Cato and so many of the other good groups, so you can hear wonderful speakers like this, and you can determine what are the issues that you feel passionate about and how would you best be able to fight those great fights for freedom. So we're going to have lunch just outside in the lobby, and we hope you can stick around and join us. Thanks so much.
Thank you.